Senator Beavers, if you would please indulge me for a minute here. I think it's very helpful to give some historical context to this discussion. We discussed last week. We threw around a lot of names. We threw around the names of Jefferson, of Madison, and Jackson, and I think it's helpful to review our constitutional history, and it's very helpful to do that, and I appreciate that aspect of this bill, is that it has caused many of us to go back and to review our constitutional history. You know, I mean, of course, the Constitution was not the ruling law of the land after the Revolutionary War. It was the Articles of Confederation. Many folks felt that the Articles were not strong enough. It didn't have a strong enough federal government. It didn't have a judiciary or an executive at all, in fact, and in particular, you couldn't levy taxes under that. So the Constitutional Convention was called in 1787. It was actually called originally to amend the Articles, though it quickly went beyond that. Interestingly enough, Jefferson was not present for that Constitutional Convention. He was ambassador to France at the time. However, his protege Madison was there. It showed up earlier than other members, drafted the Virginia Plan, which became a large part of the ultimate document, especially after the Great Compromise. And that Constitution was drafted, and it was finished in 1787 in September, and it provided for a government of limited and enumerated powers. And that's what it provided. Interestingly enough, it actually went into effect under its own terms when only 9 of 13 states had ratified it, which was different from the Articles of Confederation, which had required unanimous support to be amended. So there was an interesting question of validity there. However, in my personal opinion, having Washington there to be the presider over that convention is what gave it its ultimate authority, in that Washington was so respected as not only a war hero, as someone who was quite frankly was charming and good looking, but also because ultimately of his character and the character that he showed. And so that's where we were to try to sell this to 9 of 13 states. It went fine on the ratification process through the first 5 states, and then ratification ran into trouble with Massachusetts. And there were obviously the Federalist Papers were written in support of the Constitution. The Anti-Federalist Papers were written opposed to adopting the Constitution. The Federalists written by Madison, Hamilton, and John Jay, who would later become the first U.S. Supreme Court justice. And as with the Massachusetts Compromise, what was adopted was the idea that the Bill of Rights be added to the Constitution. And ultimately, Massachusetts did go along with that. So did 4 other states following. And we got to 9 states of ratification. It went into effect. And then the Bill of Rights was passed by Congress. It was originally 12 amendments sent to the states. Only 10 of them were adopted. One of them later became the 27th Amendment. But those 10 became the Bill of Rights, to go ahead and also specify that in addition to the federal government with limited enumerated powers, we would also have a Bill of Rights that would reserve certain powers to the people, and that would ensure that certain individual liberties were not violated. So the first constitutional question was actually over the Bank of the United States. Madison and Hamilton, who had been the 2 chief drafters of the Federalist Papers, got involved in that, with Congressman Madison arguing that you could not create a bank, and Hamilton was the Secretary of the Treasury at the time, said you could. So there you've got the Congress and you've got the executive discussing the issue. Hamilton ultimately won under the Necessary and Proper Clause. Move on to the state foreign sovereign immunity issue just a few years later in 1793. And the Supreme Court there ruled that you had in a dissent, you had Justice Iredell saying, well, the King of Britain had to consent to being sued. Interesting argument. However, he was in dissent, and the ultimate holding was, no, we're not going to follow the common law when the common law conflicts directly with the Constitution. This written Constitution is the law of the land, and it is what rules. And those who have problems with it will have to change it, and that's exactly what they did. They adopted the 11th Amendment on state foreign sovereign immunity. The Alien and Sedition Acts were the first major issue in which the whole idea of talking about these particular constitutionality by the states took place. And those Alien and Sedition Acts had said that the president can actually remove folks who are foreign citizens, And also went on to say that any sort of, with the Sedition Act, said that any sort of defamatory remarks made about the president or the Congress, that if those statements took place, then that would be punished as a crime. Obviously, this was put forward by the Federalist Party, not to be confused with the Federalists who had opposed the Anti-Federalists, but this was now the Federalist Party that was opposed by the Democratic-Republican Party. And the Democratic-Republicans, Madison and Jefferson in particular, went about writing certain ordinances. The Virginia Resolution, which we discussed last time, and the Kentucky Resolution, Virginia written by Madison, Kentucky written by Jefferson. And they declared those Alien and Sedition Acts to be unconstitutional. However, this issue then became moot shortly thereafter, after the election of 1800, because at that point the Democratic Republicans took over and had control, and those particular laws were either repealed or they simply went out of effect. With Marbury versus Madison, as the sponsor of the bill mentioned last time, did not come until 1803, and there you've got a quite clever argument by the Chief Justice that Marshall that he was actually giving up power, ceding power. What he said was, the court cannot issue writs of mandamus, which was simply an order to an executive to do or not do a certain thing. So on its face, he was making an argument to give up power of the judiciary. Of course, the secondary argument underneath that is, well, in fact, it's the courts who get to decide what is and what is not constitutional. So it was really a brilliant argument in the sense that it could not be challenged because he was giving up his own power. So the executive and the legislature could not challenge his giving up his own power in that way, and that idea of judicial review was placed into U.S. Supreme Court tradition through that. Moving on, just a few years later, 1810, the court struck down a state law as being unconstitutional under this idea of judicial review. 1819, the court agreed with Hamilton, said that that the U.S. could create a bank and that Maryland could not tax it. And then we get to the issue of Jackson. And that's what we discussed a good bit last time in Jackson. I mentioned Jackson in particular because he was a very interesting figure on this subject. He had some really disparate views from those that are carried by a number of people today and even at the time. He, first of all, was faced with the issue of constitutionality over the Worcester versus Georgia case, in which point that was a setup case, and you had a missionary who was going down into Georgia and working on some tribal American Indian lands. He was arrested at that time, and the issue went up to the court as to whether or not the state of Georgia had authority over those tribal lands. And the court said they do not. And so they struck down this criminal statute on the Georgia books. Jackson, of course, is always quoted as having said, Chief Justice Marshall has made his decision, now let him enforce it. He did not, in fact, say that. What he did write was, the decision of the Supreme Court has fell stillborn, and they find that they cannot coerce Georgia to yield to its mandate. So he wasn't particularly excited about enforcing the Supreme Court decision against Georgia. However, later, a good bit later, Georgia did finally release those two missionaries, and that avoided a constitutional showdown at the time. But he had another issue that came up right at the same time, in which the second Bank of the U.S. had now been passed through the Congress, which he very much opposed, and he vetoed it. In his veto message, he said, the Congress, the executive, and the court must each for itself be guided by its own opinion of the Constitution. Each public officer who takes an oath to support the Constitution swears that he will support it as he understands it, not as it is understood by others. It is much the duty of the House of Representatives and the Senate and the President to decide upon the constitutionality of any bill or resolution which may be presented to them for passage or approval, as it is of the Supreme Judges when it may be brought before them for a judicial decision. The opinion of the judges has no more authority over Congress than the opinion of Congress has over the judges, and on that point the President is independent of both. However, so he was very clear that he had a duty to uphold the Constitution and to uphold his oath of office as well. However, in this particular instance, much like Chief Justice Marshall in Marbury versus Madison, he was limiting his own constitutional power in that instance, and he was saying that he was not able to sign a bill that he felt personally was unconstitutional, and that was creating the Second Bank of the United States. So there really was no constitutional crisis there because he was not challenging the authority of the court directly. He was limiting his own power.
I have a question on that point.
And we'll just continue, and then we'll we'll take discussion right after that. And then we get into that nullification crisis of 1832, which is the one that's really on point for what we're talking about today. And we had this tariff of 1828. We had that was benefiting the northeastern manufacturing industry at the expense of the southern agricultural interests. Southerners were very much opposed to it. And even the vice president of Jackson, John Calhoun, went as far as to resign, to go down to South Carolina, be elected U.S. Senator to try to fight it. And ultimately, Jackson signed a compromise tariff in 1832 that lowered the tariff, but it still didn't eliminate it. It still existed on the books. And South Carolina still opposed the tariff, and that is when they adopted a nullification ordinance. Now, theirs was not nearly in as soft language as had been in the Virginia and Kentucky resolutions. They said the two acts are, quote, null, void, and no law, nor binding upon this state. They directed the state legislature to enact laws to enforce it. They even said judicial proceedings upholding these acts are going to be null and void. And they said that every official, even jurors, must take an oath to enforce this ordinance. They also said if Congress tries to close a port or send a military or naval force against the state, South Carolina will leave the Union and, quote, organize a separate government. So they were pushing this issue where it ultimately goes, which was where it ultimately went, and that was to the Civil War. Jackson's response was pretty clear. I consider then the power to annul a law of the United States assumed by one state, here's what he said, incompatible with the existence of the Union, contradicted expressly by the letter of the Constitution, unauthorized by its spirit, inconsistent with every principle on which it was founded, and destructive of the great object for which it was formed. So when faced with this idea not of separation of powers among the three branches of government, but when faced with this idea of a state government now nullifying even a federal judicial decision, at that point, Jackson was clear that he considered that to be incompatible with the existence of a union. He sent to Congress a force bill allowing him to send troops to South Carolina and giving him the authority to enforce the tariff. In the meantime, a compromise tariff was worked out in the Senate to reduce the rates even further. The force bill also passed. South Carolina avoided the controversy and ended the standoff by actually going ahead and nullifying the force bill, but rescinding the nullification on the tariff. And so that's where we were. We had a few years to buy. But then the Dred Scott decision came out, creating this idea of substantive due process, saying that the due process clause is not just procedural, but in fact there's substance about it, and throwing out the idea that there are some acts that are so inherently immoral that they are to be rejected, and there is no process through which you can go that can make them authoritative and make them legal. And what that ultimately did, of course, was it allowed a slave who had been taken into freed territories to still be counted as property. And at that point, this compromise over having some slave states and some free states was gone. And then we had the Civil War, 1861 to 1865, which solved many issues, as many wars do. Some people think wars don't solve issues, but most of the times wars do solve issues and answer questions. A court packing plan, I'm going to jump ahead here because we know most of the rest of this since then. We had that same idea of, well, the 13th, 14th, and 15th Amendments were adopted, of course, right after the Civil War, repealing slavery, abolishing it, telling what is citizenship of the United States, putting in the Equal Protection Clause, and then with the 15th Amendment, voting rights, ensuring voting rights for all Americans, all males at the time. And then this idea of, as we move forward, there are a few other ideas floating around there, and getting in the 1900s of economic substantive due process, where the court is repealing or is striking down even state statutes on wage and hour laws, saying, nope, you can't do that. FDR didn't care too much for that when his New Deal program was being struck down. So, of course, he came up with this court packing plan in 1937 to try to move the court from 9 justices to 15. That was ultimately not adopted by the Senate. In part, it was to, in part also the court had switched. Of course, we had the switch in time that saved 9. It says nowhere in the Constitution how many justices we have to have, but we've had 9 ever since 1868. And that switch by Justice Roberts allowed the court to continue on and actually to uphold that New Deal legislation, even that was affecting wage and hour laws. We get into the height of the Commerce Clause. We've talked about that in this bill's history before, with the Wickard versus Filburn case that came out in 1942. Even one person growing wheat on his own farm is engaging in interstate commerce because he is not purchasing wheat off of the market, was the argument. So you've got the real height of that Commerce Clause there. The incorporation doctrine came into play throughout the 20th century. Arguably, you can trace it to the Gitlow versus New York case of 1925. But here the idea is that the court says, well, the original Bill of Rights, the first 10 amendments of the Constitution, they only applied as constraints on federal power. But then the court, throughout the 20th century, said, no, in fact, because of the Due Process Clause in the 14th Amendment, which we already had a Due Process Clause in the 5th Amendment that applied against the federal government, but because of the Due Process Clause in the 14th Amendment, at that point now we're going to use that, and under a type of substantive due process argument, say that all the first 10 amendments, or certainly at least the first 8, also apply as constraints on state power. Brown versus Board of Education came out in 1954, saying that separate but equal is not equal under the Equal Protection Clause. And then we have more civil rights legislation that was upheld, once again, on the Commerce Clause discussion in 1964, the Civil Rights Act of 1964. You had 2 cases that came out there, the Heart of Atlanta Motel, and at this point, of course, the Congress had not only talked about and had not only got into the public discrimination, but now you're talking about discrimination by private, in this case, private employers, private restaurants, private hotels, privately owned, that is, but open and serving the public. And the court said the Heart of Atlanta Motel actually was serving 75% of its patrons that were coming there from out of state. So the Heart of Atlanta Motel was, in fact, engaging in interstate commerce, and the Congress could use the Commerce Clause to get to and regulate that activity and to say that racial discrimination, which was awful, that could be outlawed. However, the Katzenbach versus McClung case that came out the same day dealt with Ollie's Barbecue in Birmingham, Alabama, and in that case, the court had to make a more of a stretch of an argument there in finding that 36% of the meat of Ollie's was bought from one local supplier, and all of that supplier's meat came from outside of the state. So that's where it stood in 1964. We had substantive due process flipped since it had gone away against economic rights, and now it came back into play in 1965 in the Griswold versus Connecticut case as applied to individual liberties. There you had a test case with a criminal citation involved, in which there was a criminal fine for dispensing birth control in Connecticut. And the court found specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. And it found a Ninth Amendment implied right of privacy and struck down the state statute in that case, which ultimately led to the 1973 case, Roe versus Wade, that we are more familiar with. Finally, we get to the Rinquist Court, or at least when Justice Rinquist was on the court in 1995, and there began to appear limits on the Commerce Clause. In the U.S. versus Lopez case in 1995, the Gun-Free School Zones Act of 1990, which had made it a federal crime to carry firearms within 1,000 feet of a school, that was found not to fall within the Commerce Clause powers of Congress. So for the first time in certainly since the beginning of the 20th century, you now had the Supreme Court pulling back on the authority that it was willing to grant to Congress under the Commerce Clause. U.S. versus Morrison in 2000 continued that line of reasoning and struck down portions of the Violence Against Women Act, which had made it a crime to commit certain crimes motivated by gender. Gonzalez case, Gonzalez versus Wright in 2005, to some extent went the other direction in saying that no, California cannot violate the congressional powers to regulate drugs. California was engaged in medical marijuana, as it still is, as a matter of fact. And they said that Commerce can regulate that because that's ultimately part of a larger economic system of regulating drugs. And then, of course, finally, the most recent case on the Commerce Clause power of Congress is the NFIB versus Sebelius, otherwise known as the Obamacare case, from just this past summer, in which case the court on that one specific Commerce Clause issue said that Congress does not have the power to create commerce and then regulate it. And they struck down, on Commerce Clause grounds at least, the individual mandate, the requirement that individuals be forced to purchase health insurance, and then that purchase then be regulated. Now that, of course, it was obviously upheld on the Taxing and Spending Clause. And then we have a couple of other, to round it out, a couple of other Second Amendment cases from 2008 and 2010. One was mentioned in here yesterday. The D.C. versus Heller case struck down the D.C. Handgun prohibition, which even prohibited firearms in the homes in D.C. And then that particular Second Amendment provision was also incorporated to apply as a limitation on state power in the 2010 case of McDonald versus Heller that was out of Chicago. So right here in the middle of these 2008 and 2010 cases, we had Senator Beaver's original bill, which I supported. And it said that as Tennesseans, we think that our firearms or ammunition that is produced within the state boundaries and that does not leave the state boundaries is not subject to regulation under the Interstate Commerce Clause. And I supported that. And this particular bill does a number of other things in addition to that. And with that, Senator Beavers, you're recognized to describe the bill again.